Thank you very much, Shri. I think very, very interesting points. Very, very quick answer to your last question. At least in India, I don't think you're going to ever run into that problem simply because a patent infringement suit by the time it's decided, as we saw in Roche Supla, would be about good 6, 7 years. So whatever exclusivity you have on the data side would go before they actually issue an order, final order saying it's okay to infringe.
Thank God for our such slow judicial system.
But very interestingly, I think one of the points that will come up, I think in future is, given the spate of investment treaties that we are signing up to, could a potential claim be made later when you take so long to resolve a dispute on patents? First is, I mean, there are statistics coming out on the number of years that it takes to grant a patent, which they say in India is at least 5 to 7 years minimum, and then it could go up to about, let's say, 10 years, 12 years, right? So almost half the patent term. Then you go before a court, and it could again drag on. And I think companies now have made it part of their strategy that even if we get the court, if we get this case in limbo before the court for 2 to 3 years, which I think was a very clever strategy followed by Glenmark in the diabetes case in sitagliptin, which is in 2 years, if we can get the court's hands off, that's enough for us to make some kind of profit in the market, and then we'll tell the court we'll dispose of the remaining. And I think that was a clever strategy because Glenmark is a very clever company. That was a very strong patent. I can see no other reason for them doing it. So I think some very interesting stuff may come out given the nitty-gritties of the Indian system and how it plays out, which may impact global jurisprudence. So unfortunately, Vivek has to leave. He has to catch a flight. Can you take one quick question, because I'm pretty sure there will be something directed at you, and then we can let him off the hook. So is there someone with a question for Vivek? I think you're off the hook, Vivek. They're all with you. Okay. Thank you very much, Vivek, and wonderful having you. No. Package for you. So, Mr. Dilip Shah, I always call him a one-man army because that's what he's been for several years, battling consistently. I mean, you have to really salute the man's persistence and indefatigability, you know, in terms of how he's stood up to defend the freedom and the space that the Indian pharmaceutical industry and public health has enjoyed over the years within India, continues his fight against what he sees as a unilateral attempt to enforce norms and laws that may not suit the local specificities of India, has been deposing before various bodies, including the USITC and the others, drawing upon and telling upon them the fact that, well, the Indian regime is not as bad as it's made out to be by vested stakeholders. It is fairly, if you read the provisions, and I think Vivek also mentioned that many countries have similar provisions, many countries have done it. Jayashree mentioned cases of courts saying that continue to infringe, you just pay a royalty. That happens in the US all the time. I mean, if you go as far back as 1930s, the US had a case where they were pretty much did it for a technology that was meant to clean, that was meant to dispose of sewage in a healthy, sanitized manner. Somebody held the patent, and the city of Milwaukee wanted to use that for disposing of sewage so that the residents of Milwaukee would be safe and sanitized. And the patentee wasn't willing to license, and the court said, well, we're going to let them to use the patent, and they just pay you a royalty. So it started from there. It continued with a contact lens case a couple of years back, and it continues almost every day in high-tech cases, right? If you look at the high-technology industry, forget pharmaceuticals, almost every day, and you had Judge Posner, Richard Posner, the most sort of free market, and the one who infused economics into law in such a big way, right, was looking at everything through an economic lens, coming up and saying, well, in these cases, the cost of an injunction far outweighs the benefit, so therefore no injunction. So very simple cost-benefit analysis. Injunctions are costly, so let's not grant it here. Let them just pay a royalty. And this is a strong free market proponent. So I think even on its economic internal logic, these are not just a bunch of ideologues who are speaking from a left liberal philosophy, but even economists and free market economists, I think, are leaning towards this view that sometimes injunctions are just way too costly. So Dilip, as I mentioned, has had a strong history, and Dilip incidentally started his career with Pfizer, and then after a couple of years decided to jump over on the other side. 30 years, sorry. After 30 years, so he knows exactly
how would you justify ciprofloxacin compulsory license, which US was, they did not eventually grant it, but they were ready to break the patent of Bayer. As regards second question on compulsory license and pricing, Indian generic industry is not aggrieved about price control. We don't have problem with
No, that's because the IPA doesn't have a problem because they get their revenues from abroad.
just-
But the IDMA, I'm
No.
sure does
Just-
have
just-
a problem.
just
Yeah, I'm
on,
sorry.
On pricing issue, I have represented all three associations, OPPI, IDMA and IPA. And even today I represent all three. So I'm speaking on behalf of three associations. There are small scale companies which are outside these associations. I'm not talking about them, but they've confirmed their agreement with what I'm saying. We have no issue with essential medicines being under price control. Our current issues with the NPPA are four. One, we always prided in India being a country where rule of law prevails. And we see consistently there is a selling price fixation based on average selling price which is worked out by NPPA. In 2013, first time these selling prices were fixed, we have a same product, the price ranges from 10 rupees to 2 rupees. And if selling price is fixed at say 7 rupees, those who were selling about 7 had to bring their down price to 7. Those who were selling below 7 at 2 rupees, 3 rupees, 4 rupees, they had to stay there. Fine. Industry accepted that. Small scale also accepted, everybody accepted that. In 2016, with the WPI linked price changes, there was a reduction of 2.7% in prices, of selling price. The law is very clear on this. What NPPA said, that even those who are selling below selling price have to reduce by 2.7%. Now this is not in law. Now look at its impact and the propriety. We are not just challenging the legality. You have large number of small scale companies selling at 2 rupees, 3 rupees. You force this reduction upon them. They were not allowed to raise the prices. They had to continue to sell at that price. Now you are forcing them to do this. IPA has gone and filed a writ. Now this would not impact so much as IPA companies, but it would affect the SMEs, small and mid-sized companies. Secondly, with NLEM 2015, National List of Essential Medicines 2015 being adopted in the DPCO 2013, some 100 odd drugs, new drugs came under price control, and 100 odd drugs went outside price control. NPPA ruled that even those drugs which have gone outside price control, you first reduce by 2.7%. This notification was issued prior to price fixation notification, that they were no longer under price control. And price freeze for 1 year. And what, under what law? What basis? There is a, in 2014, July, NPPA invoked emergency powers under provision paragraph 19 of DPCO, which said that in public health in emergencies and for a specified period, they can fix price of any product. Fine. The pricing regulator could decide, not the recommendation of Ministry of Health, as in the case of compulsory license. But the pricing regulator decided without even clearing with his own minister that he has to bring 108 other products under price control. And he issued price fixation notice.